So in what has become quite a regular feature over the last number of weeks, we have a significant government announcement after 5 o'clock on a Friday afternoon. So the Chancellor has announced further details of changes to the coronavirus job retention scheme that will come into effect from the 1st of July. He introduced a concept of flexible furloughing, which means that from the 1st of July, employees can be brought back to work for any number of hours, and if that is less than their normal contracted hours, then the employer will pay them 100% of their wages for the hours that they work, and then for the remainder of the week where they're not working, the employer can avail of the job retention scheme to top up the wages. So the employee will benefit from 100% of pay for the hours worked and will continue to benefit from 80% of pay for hours not worked. In the month of July, the government will continue to make up all of the wages up to 80%, subject to the £2,500 cap and the employer's pension contribution and the employer's national insurance contribution. And then from August through until the scheme runs out in October, the government support will gradually taper away, and the employer will have to contribute a proportion of the wages and employer's pension and national insurance contributions for the hours that the employee is not working. Now, further details in relation to the calculations and how exactly that's all to be worked out will be published, we are told, by the 12th of June. But for now, here's just a few immediate comments and takeaways. So if an employer knows at this stage or is fairly certain that there will be redundancies and that the prospect of all employees coming back to work is slim or nil, then now is maybe the time to start thinking about redundancy exercises, because there's little point in continuing to have people on furlough and make contributions to their wages if ultimately there isn't going to be a job to come back to. Now, when the right time is to move on that will depend on, well, firstly, how sure the employer is that that's going to be the case, because they're not going to want to make people redundant unnecessarily, and also what notice periods need to be served, because there isn't going to be an employer contribution to wages unless they've agreed to top up the furlough pay until the 1st of August, and even then it's only going to be pension and national insurance contributions. So employers aren't going to have to put their hands in their pocket in a significant way for some time, but still, if you're an employer watching this and you're thinking that there will be redundancies, you now know that from the 1st of August you will have to start making a contribution to wages of employees when they're not working, and so you may want to consider the timetable around when to consult with those employees in relation to redundancies. Can an employee agree with their employer that when the government support tapers off, that they will not require the employer to top up the pay to 80%? In principle, employees can agree to pay cuts, and in fact many did agree to a pay cut to go into the job retention scheme, but in law there's lots of things that an employee can't contract out of and can't agree with their employer. For instance, the entitlement to the national minimum wage. So in legal terms, my assumption is that it will not be possible, and in fact the government has made it clear that there's an expectation that the employer will contribute to the wages, so that when an employee isn't working, they're still getting 80% of their wages for those hours that they're not working, and so it doesn't appear to me at this stage that there's going to be any possibility for employers and employees to agree to retain jobs by saying, well, just pay us for the hours that we work and just don't top us up to the 80% whenever the government starts tapering away its support. So employers are going to need to prepare, if they're going to continue to avail of the scheme, that they will from August, and then on a more significant basis in September and October, they will then have to pay a contribution to wages where the employee isn't actually working. The other thing to note is that the cap, the £2,500 cap, it's going to taper off as well in September and October, and in fact the cap is in proportion to the hours worked. So if an employee comes back in July and works half their normal hours, then the £2,500 cap for July actually becomes a £1,250 cap, because the cap's in proportion to the hours worked. Another thing to note is that an employee who hasn't been put on furlough yet won't be able to be put on furlough if they're not put on furlough on or before the 10th of June, because they're closing the scheme to new entrants from the 1st of July, which means that you need to have served a period on furlough up to by the 30th of June, and in order to do that and serve 3 weeks, you need to have started that period of furlough by the 10th of June. So if employers have anybody who they've been haven't been furloughing because they've had some work for them to do, albeit not maybe as much as would be normal, and they've chosen not to furlough them on that basis, but they would like to have the flexibility of part-time furlough in the months of July, August, September and October, then they're going to need to put those employees on a 3-week period of furlough on or before the 10th of June, or else the possibility of putting that employee on furlough will be lost. Another thing to mention is that the fact sheet along with the announcement on the government website says that employers, the amount of employees that can be claimed for will be capped at the maximum number that have been claimed for up to the 30th of June. So what that means is if employers have been rotating employees on and off furlough, say 3 weeks on, 3 weeks off in 2 teams, the possibility will not be there, it looks like, to bring everybody back and everybody does half a week. Because if everybody did half a week, then the numbers claimed for would be double what they had been previously, and the scheme rules now say that that's not going to be possible. So whatever the maximum number of employees claimed for in a claim period, that can't be exceeded then after the 1st of July. So anybody looking at it thinking, well, we can maybe bring everybody back on a part-time basis, needs to look at that carefully, because that might not be possible. So more to come whenever the details of the calculations are published on the 12th of June. But for now, I hope those few comments and pointers are helpful, and have a good weekend.